Welcome to the Physician's Guide to Financial Wellness, the podcast dedicated to helping physicians in Michigan turn their professional success into financial success while enjoying life along the way. And now, here are your hosts, Andrew Mushbaugh and Trent DeBruin.
Hi, everyone, and welcome to another episode of the Physician's Guide to Financial Wellness. This is Andrew Mushbaugh, and I'm joined, as always, by my co-host, Trent DeBruin. And today we're going to follow up on the recent string of tax-related podcasts with an even better topic to discuss on a Friday date night with your spouse, and it's estate planning. And estate planning is an inevitability that everyone will have to face, which Ben Franklin highlighted so eloquently that nothing is certain but death and taxes. So we've discussed taxes, and now we'll touch on the other certainty.
I like how direct Franklin was. It's a great segue into estate planning.
Yeah, I couldn't find a Mr. Rogers quote about easing into estate planning.
That might have been a better alternative.
Yeah, I'll remember that for Estate Planning 201. But for today, as the title references, this is going to be Estate Planning 101, so we'll keep it high level on what you need to know and avoid as much jargon as possible. We'll break down Estate Planning 101 into 5 areas. 1, the basics of estate planning and the key documents involved. 2, why estate planning is important. 3, the process of actually implementing your estate plan to reflect your intentions. 4, how estate planning changes over time and when to consider updating your plan. And number 5, the last area, is what to expect from the process of working with an estate attorney and the costs you can expect. So Trent, why don't you start us off by walking through the basics of estate planning and why it's important?
Sure. So at a basic level, an estate plan outlines several important areas, such as how your financial assets would be divided if you were to pass away, who would care for your dependent children in that scenario, and even who would make important financial and healthcare decisions for you if you didn't die but became incapacitated. In other words, it allows you to create an intentional plan for what you want to happen on the front end before anything actually happens to you. By default, everyone has some type of estate plan, regardless of whether or not you have any formal estate documents in place. The key distinction is that if you didn't create an estate plan based on your wishes, your estate plan will be decided by the government and your assets will be divided according to the government's rules. And when faced with that choice of having important decisions made based on your own intentions versus being made by the government, almost everyone would naturally prefer to be the one making those decisions. Having said that, even though most people prefer to be the one making these important decisions, there's a common misperception that estate planning is only for the quote-unquote wealthy, or that it's not relevant if you aren't near the end of your life. We'll touch on these misconceptions in a bit, but it's worth noting that estate planning isn't just for those with $100 million estates, the ones that periodically garner the news headlines. Although if you look up Prince's estate or lack of an estate plan, you can see some of the problems that can materialize. So knowing that an estate plan is relevant for a much larger percentage of the population, it's helpful to understand what an estate plan actually consists of. And there are 4 main documents that make up the foundation of an estate plan: a will, a revocable living trust, a financial power of attorney, and a healthcare power of attorney. Starting with a will, this is a document that provides instructions for how your property and financial assets will be distributed after you pass away. Another key aspect of the will is appointing a guardian for any minor children. So a will is the starting point, and in more basic situations, it can even be the sole document outlining your intentions. However, in many situations, when creating a will, you'll also want to create a revocable living trust to go with it. And this is where some confusion can enter the picture because the idea of having a trust can sometimes seem more complex than it really is. A revocable living trust is similar to a will in the sense that it allows you to provide instructions for how your assets will be split up. The main difference, however, is that having a revocable living trust allows your heirs to avoid the probate process when settling your estate. And probate isn't inherently a bad thing, but it does tend to require more time to settle the estate. It makes your estate public record, and it can be a costly process. So most people would prefer their heirs to avoid having to go through it. And the last 2 documents in a typical estate plan, as mentioned, are financial and healthcare powers of attorney. These allow you to appoint another person or 2 who can act on your behalf to make either financial decisions, like moving money from your bank account to pay bills, or healthcare decisions, like if you have a DNR or other specific health requests, in the event you become incapacitated and can't make these decisions for yourself.
Yeah, and as Trent just walked through what estate planning is and the main documents involved, it likely became a little more clear as to why it's an important area to address, which I'll elaborate on. And I'll start this off using an extreme example of how impactful estate planning can be by reviewing the late George Steinbrenner, who's the former owner of the New York Yankees, and reviewing his estate plan. He's joked about us having one of the most fortunate estate planning situations in recent history, although perhaps not for the reason you might expect. When he passed away in 2010, his estate, estimated to be worth $1.1 billion, transferred to his family without his heirs owing estate tax. While not everyone is aware of what an estate tax is, to add a little perspective, if he were to pass away today, his heirs would have had to pay over $450 million of estate taxes. So why did his heirs not have to pay estate taxes? It wasn't because he had Donald Trump's CPA helping. It was because the federal estate tax was appealed in 2010. Had he passed away in 2009, 2011, or today, it would be up to $500 million of estate taxes owed. So that's obviously an extreme example, but highlights one of the important reasons to be proactive about your estate planning, which is navigating potential estate taxes due. Now, in 2022, the estate tax exemption is a little over $12 million per person, or $24 million per couple. So you'd have to have an estate worth over $12 million before ever having to worry about estate taxes, which we know isn't relevant for most people, but is something to be aware of, especially because these exemptions clearly change over time. $0 in 2010 to $12 million in 2022. Flipping to the other end of the extreme, where instead of worrying about passing on a $1.1 billion estate, you may be closer to a $100,000 estate, so estate taxes aren't on your radar. In this case, if you're younger and single without any dependents, it may not be necessary to create a formal estate plan. But once you are married, and especially if you have children, an estate plan becomes increasingly important. And the reason why, as Trent mentioned earlier, is because you need to create a will in order to name guardians. If you die intestate, which is legal jargon for without a will or estate plan, then you follow the rules outlined by the government. In other words, your children may not have a choice but go to a guardian that you may have otherwise not wanted. Outside of naming a guardian, another important reason to have an estate plan is simply to have control over where your money or estate ultimately ends up and the manner in which it ends up going where you'd like. For example, you may have a relatively straightforward situation where you'd like everything to go to your spouse and he or she can have access to everything immediately. However, not everyone is in that position, and there may be other dynamics at play. Children, charitable intentions, nephews, nieces, or parents that you'd want to get a portion of your estate. So having a will or a trust allows you to dictate your intentions, like I want 100% to go to my spouse if something happens to me. And if something happens to both of us, then I want the money to be split in equal parts to all living children. This is another relatively straightforward example where you want your estate to be split evenly, at least in theory, but there are almost always other factors at play. For example, if you have a 15-year-old and an 18-year-old, would you want them to inherit $2 million all at once? It's different for each family, but it's fairly easy to use your imagination thinking about your child having access to $2 million all at once while in college. To address this concern, you can outline in your estate documents certain parameters where your heirs have access to the money. For example, you can specify that 1/3 of your estate is available for them at age 25, up to 1/2 by 30, and then they have access to the entire amount by age 35. This is a rough outline and just one option to add in your will and trust, but it also allows anyone with younger children to be intentional with how their money will be passed on. There are essentially an unlimited number of scenarios you can play out with your estate plan. Care for a special needs child, having different rules for each child and when they'd have access to the money, support for a sibling or nephew, or charitable causes, which all of these can be addressed and planned for by creating an estate plan. So to summarize the main reasons to have an estate plan, 1 is to plan around and ideally minimize or avoid any estate taxes. Number 2 is naming a guardian if you have minor children. And 3, having additional control and specifying your intentions of both where your money goes and the timing of people having access to it.
Yeah, that why behind estate planning isn't always intuitive or something people think about often, but as you can see from what Andrew shared, it's clearly an important area to address, and doing so tends to provide some nice peace of mind that everything is covered. So we know that having an estate plan is an important part of having an overall financial plan, and the next step is understanding more about the process of actually implementing your estate plan. And we break it down into 2 parts. Step 1 is creating the key documents of your estate plan, will, trust, and powers of attorney for healthcare and property. Well, step 2 is the process of titling your investment accounts, assets, and insurance policies to reflect the estate planning documents you created. In other words, implementing your estate plan. Looking at step 1, there are several ways you can create your estate planning documents, although the most common route, and the one we strongly encourage, is to work with a local estate attorney. There are cheaper options, such as creating an estate plan online by yourself, but given that this is a one-time cost and the documents will be relied upon for many important areas, you want to make sure it's done right on the front end. So that's step 1 of creating your estate plan. However, it's common for people to address step 1, but then never follow through with step 2, which, fortunately, by having a will that serves as a catch-all document for any account, asset, or insurance policy that wasn't properly titled, you have some protection here, but it does result in more work for your heirs going through the probate process and greater potential for something to be missed. If you're working with an estate attorney, they'll almost always provide an outline or summary with instructions for how to address step 2 in terms of updating your beneficiaries and the titling of your accounts, assets, and insurance policies. And just to provide a bit more color here, a beneficiary is a person or entity you list on a retirement account, like an IRA, 403b, or 401k, or a life insurance policy that specifies where the money will go if you pass away. You can list a primary beneficiary and a contingent beneficiary and specify varying percentages for different beneficiaries. For example, you could list your spouse as the primary beneficiary and your revocable living trust as your contingent beneficiary. Alternatively, you could list a charity as a 25% beneficiary and your child as a 75% beneficiary. You have complete flexibility over how you choose and specify these beneficiaries. It's also worth noting that reviewing your beneficiaries periodically is really important because it's easy to set them on the front end, then forget to adjust them as life changes, such as leaving a divorced spouse as your beneficiary or not adding an additional child as your family grows. Outside of updating your beneficiaries for your retirement accounts and insurance policies, you also need to update the titling of your other assets. These include bank accounts, your primary residence, any rental properties, taxable investment accounts, etc. Again, your estate attorney should provide the exact instructions for how to update the titling of your assets, and doing so will typically involve you completing some paperwork, like updating the deed for your primary residence if needed, or completing paperwork to retitle your taxable investment accounts to your trust.
Yeah, it's a relatively straightforward process, but we know it can be tedious and easy to push off. Fortunately, creating and implementing your estate plan isn't something you have to regularly go through or update, so it can be 5 to 10 years before you have to go through the process again. However, your estate plan shouldn't just be a set it and forget it or check the box type item. It is something you should periodically check in on. As Trent just mentioned, there are situations like a divorce, getting married, or having another child that are more direct prompts that you should check in to ensure your beneficiaries are updated and that your current estate plan still reflects your preferences based on any changes in your life. But those aren't the only times to review your estate plan. 2 other common reasons to revisit and review your estate plan are based on a material change to your wealth and/or changes in tax legislation. Looking at the first area of a material change in wealth, we view this as a material change in wealth from the last time you updated your estate plan. For example, you may have set up a will 10 years ago when your net worth was $100,000, but now realize your net worth is $2 million. In this case, you'll want to revisit several areas, like if you're worried about estate taxes resulting from any legislation changes. Would you be more comfortable with XYZ person inheriting $2 million at the current ages listed? Or would you like to adjust that given the higher dollar amount? You certainly don't have to make a change because your wealth is increased, but you should at least revisit your documents, life situation, and family dynamics. Another time to review your estate plan comes into play periodically and is a result of legislation changes. Similar to changes in the tax code, there are periodic adjustments or changes to estate tax laws that may result in your current estate plan becoming outdated and requiring you to update your estate plan or risk some unwanted consequences for your heirs. As an example, let's assume you have a $10 million estate and at least under the current laws are not worried about having to pay estate taxes. Well, if there was a change in legislation where the estate tax exemption reverted back to a significantly lower level of $1 million, you'd be looking at $9 million that would now be subject to estate taxes. So in that situation, you may or may not decide if you want to make adjustments to your estate documents, or if you should start considering any proactive planning, like annual gifting to your heirs, charitable gifts, or setting up other trusts with the goal of getting money, quote unquote, out of your estate, thus lowering the amount subject to estate taxes. Stepping back, when looking at your estate plan and taxes in general, it's important to balance the financial side of the equation with some of the softer areas, like any additional headaches or work added to your plate or your heirs as a result of this added complexity. You certainly would like to keep as much money in your pocket for your heirs or charity relative to paying taxes, but most people would also like to ensure a smooth process for their heirs with settling your estate. So one factor to consider as a result of estate law changes is managing the potential for estate taxes, but there are other areas to consider too. I won't go too far in the weeds here, but following the Secure Act that was passed a couple years ago, there were several changes that had a material impact on estate planning strategies. Not everyone needed to update their estate documents, but it was worth everyone reviewing their situation to see how the changes impacted them. One of the biggest changes was around inheriting IRAs. Prior to this legislation, if you inherited an IRA, you were required to take money out each year and pay taxes on the distributions, but could stretch those distributions out over your lifetime. Well, following that legislation change, any non-spouse that inherits an IRA has to distribute out the full amount within 10 years. There are several other nuances involved here with the specific time frame, but the punchline is that your heirs may be faced with a larger tax burden than expected. In some cases, there's no planning required, while for others, there are significant implications where you could save $100,000 plus in taxes by adjusting the overall strategy from both a tax and estate planning perspective. So the main punchline here is that your estate plan isn't just a one-time event, and you want to periodically review your estate plan over time, especially as a result of any material changes in your life situation or as a result of legislation changes.
Yeah, unfortunately, that's a common theme with most financial planning areas. There's rarely anything that can truly be set it and forget it. Things change, and you have to evolve and adapt when that happens. So we'll wrap up this episode with a brief overview of what to expect and what to be prepared for when actually going through the process of creating an estate plan. As mentioned earlier, we strongly encourage people to work with a competent estate attorney, ideally one in your local area, since there are state-specific considerations when it comes to estate planning. In terms of working with an estate attorney, each firm or attorney might have a slightly different process, but it generally follows the same overall framework, which consists of first, gathering the required information to draft your estate plan documents. Second, reviewing the documents with you to ensure they accurately reflect your wishes. And third, outlining the instructions for how to implement your estate plan documents and properly title your accounts, assets, and beneficiaries. So on the front end, it's helpful to provide, or at least have readily available, a list of all your financial assets and liabilities. In other words, your net worth. This allows your estate attorney to understand your life from a financial perspective and whether there are any unique considerations that need to be factored in based on your net worth. This also helps them provide specific recommendations for any required changes in titling. Outside of understanding your financial situation, your attorney will also want to learn more about your unique situation, values, and intentions. This will consist of gathering information like your family situation, kids, spouse, any specific family dynamics, and your intentions for the money. Does it all go to your spouse and kids? Do you have charitable intentions? Do you have certain ages or limitations you like to incorporate? Like having your kids have access to the money spread out over ages 25, 30, and 35? Your attorney will also ask questions about the key people you want to help ensure your intentions are followed, which includes listing your trustee and executor, the people who are tasked with and granted power to implement your estate plan after you pass away, as well as guardians and who you would want to make healthcare and financial decisions on your behalf. So you want to have at least thought through who these key people would be ahead of that conversation, if possible. From there, once you receive a copy of the estate plan draft, you'll review it to make sure the names are all spelled correctly and everything from your conversation is accurately reflected in the documents. Then, as mentioned, the last step is following the attorney's instructions to retitle your accounts, assets, or beneficiaries based on their recommendations. In terms of price you'll pay, it tends to vary widely based on geography and the size of the law firm you work with, but for example, for the full suite of documents, will, revocable living trust, and powers of attorney, you'll likely pay between $2,500 and $5,000 in our local area in Ann Arbor, whereas for that same package in the city of Chicago, you might be looking at something closer to $6,000 to $10,000. Everyone has a different preference, but we like to find that sweet spot in terms of a competent attorney at a fair price versus paying for a quote-unquote brand name at a larger firm. So when thinking about the costs, it's certainly not insignificant, but fortunately it's a one-time expense on the front end. Then over time, if you make periodic tweaks and revisions, you pay a smaller fee for those.
Yeah, and paying for an estate plan, insurance premiums, and taxes are 3 expenses that everyone loves paying, right?
Of course.
Well, that's everything that we wanted to cover around Estate Planning 101. Hopefully this was a helpful overview and gave you a good overview of what estate planning is all about and why it's so important. So to give a quick recap of what we discussed today, number 1, an estate plan is simply creating an intentional plan outlining your intentions. The key documents involved consist of your will, which lists your guardian and gives instructions as to how your assets will be split up, a revocable living trust, which is similar to a will but allows you to avoid probate, and powers of attorney for healthcare and financial decisions, which outlines who can make key healthcare and financial decisions on your behalf. Number 2, estate planning isn't just for the ultra wealthy, and there are several reasons why you should have an estate plan, from naming a guardian for minor children, avoiding estate taxes, to being intentional with who inherits your estate and the timing of when people have access to it. Number 3, after understanding the basics of what an estate plan entails and why it's important, you should be aware of the 2 steps involved with implementing an estate plan. This consists of 2 parts. A, creating formal estate planning documents like your will, trust, powers of attorney, and B, titling your accounts, assets, and beneficiaries properly based on your formal estate planning documents. Number 4, even after creating and implementing your estate plan, you should understand this isn't a set it and forget it planning area. There will still be times when you'll need to make adjustments to your plan based on changes in your family or life situation, a material change in wealth, or changes to legislation that impacts estate planning over time. And the last area, number 5, when working with an estate attorney, it will be helpful to gather information ahead of your initial call, which consists of the financial aspects of your life, like your net worth, along with details about your unique situation, family dynamics, and intentions. In terms of cost, it will vary based on where you live and the size of the firm the attorney works at, but you can expect to pay anywhere between $2,500 to $10,000 for the estate planning package we outlined. Well, thanks everyone for joining us for another episode of the show. You can find the show notes at the podcast page of our website, mdwmllc.com/podcast. And if you have any thoughts to share or questions you'd like to have answered, please feel free to shoot us an email at info@mdwmllc.com. Take care, everyone, and we'll look forward to talking to you again soon.
Want even more ideas, tools, and resources on how to make smart financial decisions? Check out the resources section of MD Wealth Management's website at mdwmllc.com, where you'll find additional knowledge and insight from Michigan physicians, including a blog, ebook, and one-page guides. While there, you can also schedule a 15-minute conversation with Andrew and Trent to learn more about what it means to work with the firm and how they serve physicians. If you've enjoyed the content, please leave a review on iTunes and share with your friends and colleagues. Thanks so much for listening. Andrew Mushbaugh and Trent DeBruin are certified financial planners, principals, and co-founders of MD Wealth Management, a registered investment advisory firm in the state of Michigan. All opinions shared in the show are for general information and are not intended to provide specific advice or recommendations for any individual. All performance referenced is historical and no guarantee of future returns. Please consult with your legal advisor, your tax advisor, or your financial advisor before making any decisions.